Hello everyone, and welcome to the second video in our Think About It Thursday series, where we learn and talk about issues of importance to post-secondary students. Today I'm joined by Tammy, Wohler, who is a barrister and solicitor with the Social Justice Office of Nova Scotia Legal Aid. Today Tammy is going to educate us all about tenancy rights, which has been a very relevant topic during COVID-19. Thank you so much for being here, Tammy.
Oh, thank you for having me. I'm pleased to help out.
Wonderful. So Tammy's going to share her screen and share a little bit about herself and about the presentation. So I'll pass it over to Tammy now.
Okay, thank you. Just bear with me a moment while So the first thing everyone needs to know about residential tenancies in Nova Scotia is that it's governed by the Residential Tenancies Act. And I'm going to call that the RTA for the rest of this presentation. But what that does is sets out the law for landlord and tenants, relationships, rights, and obligations towards each other. It's intended to protect both landlords and tenants, and it sets out a process to resolve disputes. When I talk about disputes, I really mean bigger disputes regarding, rental arrears, illegal practices by the landlord, not maintaining the building or the unit. It's really not intended to address kind of everyday, ongoing issues between a landlord and tenant or between tenants. And so the first thing I want to talk about is leases. If you're in a landlord and tenant relationship, then you have a lease, even if it's not in writing. It could be completely verbal, as long as you're living in a place that's not a university residence, then you have a lease. And that means you're covered and protected by the Residential Tenancies Act. So when we talk about written leases, there's important things to know. So there's the standard form of lease that's set out in the regulations to the RTA, and that's easy to get from the Access Nova Scotia website. If you go to the Access Nova Scotia website, there's a tremendous amount of information that's easy to understand for tenants and for landlords about all kinds of areas. So I encourage you to go there. But as well, a lot of landlords enter non-standard form leases. Sometimes just a little write-up that each person signs. Sometimes it could just be some emails back and forth. Some people just have it by text, okay? Regardless of how it's drawn up, a non-standard form of lease cannot violate or contradict the RTA or any other law. So if your landlord decides that he doesn't like the standard form lease because it provides limitations on rental increases, he can't form up a new lease, draw up a new lease saying, I can increase the rent every 6 months. If he did and if you signed it, that's not enforceable. And that's the type of thing you would bring file with the tenancies program to have addressed. So there's two kinds of written leases, and this is something that's really important for students in particular to be aware of. There's fixed term leases and periodic leases, and they give you very different rights in terms of how the lease can end or continue. So it's really important that you check your lease. And if this is a copy of the standard form of lease, and you'll see where I've highlighted. So a periodic lease is one that renews itself, whether it's year to year, month to month, week or week. The tenancy continues until the landlord or tenant gives proper notice to end the lease. And the landlord needs specific reasons to do that. It can't be just that, well, I'm tired of you, we're not a good fit. It has to be a reason under the Act. This is a big contrast to a fixed term lease. A fixed term lease is one that has a start date and an end date. And a lot of students would see this because perhaps they only want to rent a place from September to May. In that case, you might want to enter a fixed term lease because your obligation to pay rent ends at the end of that date. Fixed term leases can be extended, but only with consent of the landlord. And so the landlord doesn't have to give a reason. He can decide that he doesn't like your new hairstyle, and he can decide not to continue the lease. So it's very important to know those differences. And so fixed term leases, as I've said, has a clear start and an end date. It may be renewed if the landlord agrees. And so normally you'd want to sign a new lease and set a new end date. Or maybe you want to move to a periodic lease, which is self-renewing. Or if the tenant continues to stay with consent. So perhaps no new paperwork's been done, but May's passed, I'm there, I paid my June rent, I paid my July rent, paid my August rent. It becomes a month-to-month periodic lease. Fixed-term leases are used for different reasons. Sometimes it's because the landlord wants a probationary period. It's a lower risk for the landlord because there's a definite end to a tenancy. The landlord, he or she, can make the decision as to whether or not that person can stay. It is higher risk for tenants. We often see sometimes tenants being promised, well, we'll try a fixed term lease, we'll do 3 months, or we'll do 6 months, maybe we'll even do a year, and we'll next time around when we go to renew it, we'll move you to a periodic renewable lease. But if there's no agreement to continue, then there's no agreement to continue, and you're faced with that lease ending. The advantage of periodic leases, if you want to stay in a place for a longer period of time, not just the school year, for example, is that you have immediate security of tenure. It means that once you're moved in and you're paying your rent, you're good. It automatically renews at the end of the period. You don't need the landlord to agree to renew. I do know we have a lot of landlords saying, well, we're not renewing your lease has become due, we're not entering a new form, new agreement. That's irrelevant, it doesn't matter. You still have tenancy. The landlord just can't make that decision on its own. Verbal leases, as I mentioned earlier, are just as binding as written leases. You're still protected under the Residential Tenancies Act. It would be considered a month-to-month periodic lease, and it's assumed to replicate a standard form of lease, and it cannot violate the RTA. Okay, so you're still protected. Obviously, it's better to have something in writing because then you have proof, right? You prove that you live there. You have proof as to what the agreement was, as to what the rent is, whether or not you paid a deposit. All those things are important. Any lawyer will tell you it's always better to have things in writing. So when we end a lease early, and that's something a lot of students may be looking to do, there's 2 ways. Okay, well, there's many ways, but there's 2 ways in particular I want to talk about because I see this a lot. So I'm sure on campus you hear a lot about subletting places. So if you've entered a lease and you're renting an apartment and you decide, you know what, I'm moving back home, I'm moving in with another friend, circumstances have changed, but I have someone wanting to move in, I'm going to sell that to that person. If you're the tenant, if you're tenant A, and you sublet to tenant B, you are still responsible for the rent being paid, any damage to that unit, any damage that other people might cause to the unit. You are on the hook. You're the one on the lease. Essentially what happens is you become like a sub-landlord. You're responsible to your landlord, and your new tenant, the subletter, is responsible to you. But that's small comfort when when tenant B, the person you've subletted to, has taken off without paying the last 2 months' rent. The landlord only knows how to get a hold of you. So if you find yourself in a situation, you don't want to sublet. If you're not planning to come back to that unit, I would strongly recommend not subletting. You want to assign your lease. That means that you've assigned all the rights and responsibilities under that lease agreement to tenant B, to the new tenant. Tenant B is responsible to the landlord, you are not. Okay? Either way, subletting and signing does require the consent of the landlord. And some landlords will go, no, there's no subletting. The Act does protect you in that regard. A landlord cannot unreasonably withhold consent to sublet or to assign the lease. They can reject a particular person, for example, because perhaps that person doesn't have good credit, has bad landlord references, for whatever reason, but he has to be able to articulate why that subletter or potential tenant's being rejected. So again, main point here is assign, don't sublet. If you're going away for summer and want to come back to that apartment, then perhaps you want to sublet for 2 months while you're away. But again, you want to vet everything very carefully. You want to make sure that you trust the person moving into your spot because at the end of the day, you're the one responsible. So let's talk a bit about finding a place. There are landlords across the city, across Nova Scotia. I think everyone knows at this time, it is very difficult to find a place. Our vacancy rate is at an all-time low. We're in the middle of a pandemic, and so things are tough out there. So that being said, I'm going to give you some advice and recognize that sometimes you don't have a lot of choices, but there's some things you need to know. So first of all, you want to take the approach of buyer beware, okay? Like anything else, when you enter an agreement, and perhaps even more importantly than other things, once you've agreed to move into a place, you've committed to it, and sometimes you're stuck with what you get, okay? So it's really important that you, first of all, read the lease before signing. And I've had many, many people come in here saying, well, yes, I signed, but I didn't read the whole thing. I didn't have time to read it. And I initialed everything that said I read it. That's not going to fly. If you're signing something without reading it, you're still taking responsibility for it. And it's very hard to argue that, well, I didn't read it. Another important thing to think about is that look at the actual unit. Sometimes a landlord will want to show you an empty unit because yours is not ready yet, or because there's tenants in there. Don't fall for that. You want to see your unit. There's no reason you should not be able to see your unit. If it's in the middle of being cleaned up, that's fine. You can accept that it's being cleaned up. If there's tenants in it, you still have the right to see it. A landlord is permitted to show a unit to someone, to a new tenant, even if the old tenants are still there. Okay, it just gets arranged as appropriate. The other thing I would recommend is that you take pictures before you move in, like on that first day, and very careful pictures, and also the date you move out. Okay, this is to show this the place looked like when I moved in. This is what it looked like when I moved out, and so it protects you against any claims for damages afterwards. And I can't stress enough how important it is to have proof of everything that you do. So proof of payment, so receipts. Some people pay in cash. I kind of shudder at that, but people do pay in cash. If you're going to pay in cash, get a receipt. If you don't get a receipt, then it's so easy to say that you've never not paid it. E-transfers, direct deposit, those are all good ways to pay rent because it tracks everything. It makes it very difficult for the landlord to say that you've not paid your rent. Or I've seen situations where property managers have taken cash from tenants and the cash was stolen, lost, etc. Right? And then it becomes, well, who's at fault? So keep track of everything and be wary of any place where they want you to pay in cash and won't give a receipt. Okay. If you have any problems, the first thing you want to do is keep a record. I have people coming to me after a year of trying to get a landlord to fix a leak, for example. But of course, when we file, we file with the tenancy program to try and resolve the dispute, to get the work done. The landlord says, well, I've never heard of that. I did not know this was an issue. So keep a record and create a record. You want to put everything in writing. I'm sure a lot of people now are using text and emails. Text and emails are a way to keep a record because it's dated, timed, and if the landlord responds, you have that record. You have the response promising to do X and Y by this date. Okay. If you get requests and promises from a landlord, and particularly if you're moving into a place, this is another thing I hear a lot. I looked at the unit, it needed paint, there was a broken window, there was a screen missing, there's a list of things that needed to be fixed. If that's not in your lease, and he's promised to fix it, and it's not written down, then it's just as good as making a wish on a birthday cake. It's not, has very little value. What you want to have it written down. You want to have an estimate as when the landlord is looking to deal with that, when's the painter going to come in, what's the plan, all those sorts of details. And sometimes a landlord will forget to put it in writing, and can be a bit of a way around that. As you're negotiating with the landlord, or as you moved in, you might have seen that something wasn't fixed. A nice, brief, professional email or letter to landlord saying, hi, I'm really happy in my new place. Oh, as you may recall, we agreed that you would fix the screen on the window, the door handle, the plumbing, whatever the case may be. Can you confirm when that will be done? Right? So then you put it in the landlord's court, essentially, and the landlord can respond saying, I don't know what you're talking about, or, oh yes, of course. Yeah, we'll get that fixed away, right? But talking back and forth, promises made in the hallway or in the front door of the apartment building are meaningless, okay? And not just because people, I'm not trying to imply that landlords are going to mislead you. I mean, some will, but some just generally forget, okay? If you're in a big building with a lot of property managers, they're going to forget. So get it in writing, keep it brief, professional, and dated. I always think to myself before I send something, no matter how angry I am, my test is, how would I feel if this was just put on the front page of Frank Magazine or Postal or Facebook or Twitter, out of context, how's that going to make me look, right? It's always think that way, and because it will be out of context, and if that's printed off, if you send something that's rude or disrespectful or vulgar, that can be printed off and given to the tenancy officer through the residential tenancy speed program as evidence of a poor relationship, disrespect to the landlord, and the tenancy can be terminated. So keep it all nice and professional. Right, and so if you do have problems, the first step is to negotiate with the landlord. Again, keep it all in writing, like you just talked about, okay? And keep it friendly and keep it reasonable, okay? For example, so if you have a problem that you want to fix immediately, say my stove's not working, I want it fixed immediately. If someone comes to your door that afternoon, yes, you're entitled to 24 hours notice, but perhaps it's not reasonable to say I want something fixed immediately and say, no, you can't come in because you didn't give me proper notice. So it's always about trying to make things work, right? That's part of negotiation and cooperation. If you have significant issues, if you think that there's real problems with the place, in terms of water damage, structural damage, safety issues, health hazards, black mold, then call, if you're an HRM, then you call 311 and ask for an inspection by a building inspector, okay, or by law enforcement, and they will make the arrangements. And if there's significant problems, then they will issue what's called an order to remedy, give the landlord a certain amount of time to follow up and fix that, okay? But it's also important to stay diligent yourself, because sometimes the inspectors are told something's been fixed and the tenant's satisfied, and perhaps that's not the case. And so it's always important that if there's a problem and it's not being resolved, to be diligent about it, and again, keep a record of that diligence. To resolve disputes more formally, which I've alluded to earlier, one would make an application to the Director of Residential Tenancies, which is a Form J. And when I say Director of Residential Tenancies, there is a Director of Residential Tenancies in Sydney, but what happens is that you get a hearing heard by a residential tenancies officer on his behalf. Okay, so there's a number of different residential tenancies officers, and these hearings are always done by phone. And that was even pre-COVID. They've been handled by phone for the last couple of years. And so a Form J can be filed by either a tenant or a landlord. And when you, so I can go back for a moment. The other thing I want you to know is that when you do file Form J, when you'll get a date for a hearing, you'll have to serve the landlord, and you'll have to provide evidence, if you're providing evidence other than what your testimony would be. So if you're planning to file pictures, etc., you'll get a date to file that by. But the other thing you need to know is that when you start the hearing, the first thing the tenancy officer is going to do is offer a chance to mediate. And often these disputes can be resolved through the mediation process. Okay. If you do agree to something through the mediation process, make sure it's something that you feel comfortable with, that you don't feel that you've been bullied into, and that you can live with. Okay. So it's very important, because sometimes people feel a little bit pressured to enter an agreement. If you're feeling pressured or need time to think about it, let the tenancy officer know. Okay. So when you're going to hearing, you'll want to file evidence. So pictures are often a good source of evidence. For example, those pictures you took in the last day of your tenancy to show that, look, there's no damage. It was clean. I didn't leave any garbage. I didn't leave any that needed to be disposed of. Looks great, right? So that's good. Screenshots are something I use a lot because oftentimes when there's a dispute between landlord and tenant, odds are they've been chatting about it by text prior to filing the Form J, okay? And so if you want to show a particular text, you need to put the whole context in because it's not enough to say that, for example, I was here to let the plumber in, he didn't come in or didn't show up. You put that in, but if the response is the landlord, well, no, he didn't arrive because, as I said in my email to you earlier, he was sick and we try to reschedule for another day, right? So you want to make sure that that context is in there and show everything, essentially almost like slide by slide. You can have a little bit of overlap so that we know, the person making the decision knows that you've not left anything out. Because it looks like you left something out, then it's going to look like you left something out that's going to hurt your case. And so that's what people will do when I talk. So I have in the slide here, there's no gotcha moments. This isn't about getting a gotcha moment. This is about proving your case, showing all of it, warts and all, and relying on the fact that your evidence is sufficient in its entirety. Okay, so it's better to be transparent. So let's talk a few minutes about the basics of rent, because sometimes people will come to the office looking for help, and I wish that they had come to us soon as they need help now. They misunderstood their obligation to pay rent. So first of all, I'm going to talk about an anniversary date. The anniversary date is the date your tenancy started. The move-in date or the date you signed the lease, and applies to both the written and leases. The reason the anniversary date is so important is that that date is used to determine what can be increased and when the notice of rental increase must be given to you. And a change in services that are provided by that are part of your lease or reasonably connected to your use of the unit is also treated like a rental increase. And so when a landlord wants to increase your rent, he must or she must do it only on the anniversary date, but it must give you 4 months notice prior to the anniversary date. Okay, he can give you more notice than that. The landlord could give you 6 months notice if they're going to change your rent on the anniversary date, but it has to be on the anniversary date. If you're getting notices that, oh, your rent's going up next month, then that's not valid. You can disregard that. Okay, so in the first year, there certainly should be no rental increase. You might get notice 4 months prior to the end of that first year of a rental increase coming, but it can't take effect in the first 12 months. And as I mentioned, so the landlord must give you notice 4 months prior to the end of your lease or anniversary date. There is no limit on how much the landlord can increase your rent. And that's very different than a lot of other provinces in Canada, but we don't have formal rent control here. If you feel that your landlord has filed, is seeking a rent increase, because he's retaliating, because perhaps you called 311 for inspection or raised a concern, or that he wants you out for some other reason, or that you feel the rent is completely unreasonable, then you can file Form J and ask the tenancy officer to look at it. So we run into a lot of people withholding rent. They're mad at their landlord. The landlord has acted very poorly, has done bad things, perhaps has been completely inappropriate, been rude, has refused to fix things. You can't withhold your rent. 2 wrongs do not make a right. It's better to pay under protest than not pay at all. Because if you don't pay at all, then you can get yourself evicted. A lot of people think that, well, put the money aside and pay interest taxes Nova Scotia. It's a common misconception. Well, technically, there is room in the legislation, in the RTA, for that to take place. it's not set up that way. There's no such service right now at Access Nova Scotia or through the Residential Tenancies program. So if you feel you in a position where you should be withholding rent or have a right to withhold rent, first of all, don't. Just stop right there, and you file your Form J with the Tenancy Board. Because then the tenancy officer can tell you, well, yes, you shouldn't be paying rent for this at this point. Or perhaps he'll tell you, or she will tell you that, no, you had to pay your rent, but your problems are not significant enough to warrant no rent being paid. Or maybe it's somewhere in between that you will get a rent rebate. So perhaps your rent will go down a little bit for the next few months. Maybe it'll go down a lot, but it depends. But you can't take it in your own hands. There's just so much risk to that. And speaking of risks, so we're going to talk about evictions for a little bit. When can you be evicted? Well, rental arrears, if you don't pay your rent, you can be evicted, and I'll go into details in that in a moment. A breach of statutory conditions or rules. So that statutory conditions are ones that are set out in the RTA. And also a breach of landlord's rules. Now, these are rules that form part of the lease. They're not rules that a landlord kind of makes up on the fly, or that passes because something's irritated him or her. It has to form part of the lease. And if there's new rules, it's kind of like new services or a rental increase. You're entitled to the same notice you would get a rental increase or service. It's 4 months prior to the anniversary date. You can also be evicted if the landlord requires your unit in good faith, meaning honestly, in limited circumstances. So major renovations, they need the unit for themselves or a family member because they're going to move in. That would only apply if it was a small building, like 4 units or less. Obviously, if you're a landlord and own 5 buildings that are 80 units each, you can't argue that you need one of those units, your unit, for a family member. Okay. You can also be evicted if the place is no longer habitable. So if there's been a flood, if it's been condemned, then you can be evicted. And this seems a little bit obvious. The reality is that sometimes tenants don't have a place to go, and we have to try to sort out where they can go in the meantime, or trying to delay the building being condemned, or try to sort things out in the meantime. The other one we see is if the tenant's in a unit as an employee. So let's say you've been hired as a property manager or security guard, and with that comes an apartment. And perhaps you're paying a reduced rental amount. You're still a tenant usually, or you get paid a lesser amount because you get a unit, and so that you're paying rent through your work being done. So you don't have the same rights in terms of security tenancy. If you are dismissed from your position, then yes, you're going to, if the tenancy can be terminated. Now there's issues as to how immediate that can be, and that's going to be something that one could argue. If you've been there just a few weeks, then perhaps you can have perhaps the lease will be terminated more quickly. If you're there for a long time, then perhaps you need more time to get out. But again, there's nothing set in stone in terms of what happens when you're an employee who loses their employment and thus loses their rental unit. And so that's something that you would really want to get help through the filing of a Form J and assistance of a registered tenancies officer. So I'm going to talk just very briefly about statutory conditions. So the statutory conditions are set out in Section 9 of the RTA. Those conditions apply to all forms of lease, whether they're written or verbal, and sets out your obligations as tenants and the obligations as landlords to you. And a breach of those conditions can lead to an eviction. So the first one is condition of premises, which applies only to landlords. So basically that means that the conditions need to be suitable for living in. And so we talk about condition of premises, we're not talking about, well, maybe it should have been repainted, or perhaps drawers are getting stuck. We're talking about things that are fairly significant, or things that really impact the ability to live there, have quiet enjoyment of the unit. Also services. So if you were provided services, for example, power with your lease, then the landlord needs to continue providing them that power. If the landlord decides that he or she wants to change that, then it's the same rule as with rent increase. You have to be given 4 months notice prior to the anniversary date, and the change is going to take effect on the anniversary date. So good behavior is another one, and that really what that means is that they don't want bad behavior. And so it applies to both landlords and tenants, but realistically has a bigger practical impact on tenants. Because if a tenant's misbehaving, causing problems in terms of, maybe they're partying all night, bringing people into the building or into the unit that are causing damage, or being loud, violent criminality, being disrespectful to the landlord on an ongoing basis, fighting with other tenants, making people feel scared or insecure, that all falls under this section here. And the remedy is the landlord can seek your eviction. A landlord can also misbehave. The remedy is a bit more difficult because there is no way to get, there's no way to receive damages for emotional harm or for stress, that sort of thing under the Written Tenancies Act. You can ask to end a tenancy early because the landlords are misbehaving, but otherwise there's not much other than asking to leave the apartment, which sometimes is not an option for people given low tenancy rates. There's also the obligation of the tenant to maintain the unit in a reasonable state of cleanliness and repair. Okay? If tenants are not taking care of the unit, and I'm not talking about general housekeeping, I'm talking about having so much stuff in the place that exits are blocked off, or garbage being kept around, or leaks are not being reported. So things are really going to cause problems for the unit, then that can lead to your eviction. Okay, I mean, it's not a judgment on your ability to clean house. It's to maintain it in a reasonable state of cleanliness. Okay, you don't have to be Martha Stewart, but it has to be safe and secure, and nothing's going to cause, not going to attract problems such as leaks, moles, or pests. Okay, and the next statutory condition is compliance with city bylaws. This applies just to mini homeowners. So if you own a mini home and you rent a lot, you're responsible for making sure that your mini home complies with city bylaws. All right, so we talked a little bit about landlord rules, and a landlord can make reasonable rules, which of course is very subjective. What I consider reasonable may be unreasonable to somebody else, and a breach of those landlord rules can lead to eviction. Okay, but the rules must be reasonable, and the statute actually sets out what that means. It must be intended to promote the safety, comfort, or welfare of persons working or residing on the premises, or to protect the landlord's property from abuse. And so we see a lot of different rules. We see rules around smoking. We see rules around animals, and all those are considered reasonable. It's not reasonable if you're told that you can't, for example, keep a pet, but everyone else in the building has pets. So it has to apply to everyone. If you feel a rule's unreasonable, you can ask to have that rule set aside by making the application to the Director of Residential Tenancies. And so here are some legal resources. If you have any questions, we have our online chat, Wednesdays from 3 to 5 at our website. And there's also lots of resources of Access Nova Scotia. We have the Legal Information Society of Nova Scotia, which is a fantastic resource for all kinds of areas of law. They have a website, they have phone numbers, they have an online chat as well, and they cover so many different kinds of law. There's also Dalhousie Legal Aid Service, which provides services to low-income individuals in all kinds of matters, including residential tenancies. And there's also a guide to small claims courts at the court's website.
I want to bring up two questions I hear a lot from students when talking about tenancy rights. And one is about kind of how or where would you find kind of really good landlords in the city, or whether places like Kijiji are really reputable places to be finding apartments when they come to the city.
Okay. So when finding a landlord, the first thing I would say is, first of all, buyer beware. You want to look for warning signs. So like I mentioned earlier, if they're not showing you the unit, if they're refusing to show you the lease, or if they're refusing to, or if they're asking for things that are not legal, like extra application fees, that sort of thing, right? You don't charge application fees in Nova Scotia, or they're charging more than they should for security deposits. Those are all warning bells. There isn't a registry of landlords. You can always research online or on Facebook. There's different groups that kind of talk about who are good landlords, give you recommendations. Certainly, if you Google bad landlords in Halifax, you'll see some names come up. It just tells you where the problems are. It doesn't tell you who the good guys are, unfortunately. But so really it's a word of mouth. When you find a place or a building, Google the building. It might give you a sense of, what other tenants have said. There's also bed bug websites in Nova Scotia that sets out places to be aware of in terms of bed bug problems. It's a lot of trying to talk to people who are local and people who've had experience, right? It's kind of like anything else. You want to get recommendations from people you know or trust and have no interest in the outcome. Kijiji, again, there's nothing inherently bad about Kijiji, but anyone can post an ad. So it really, you're gonna have to kind of dig around. Okay, you're gonna look at the ad. Does the ad look reasonable? Does it look like is it asking you to do things that are illegal or asking for application fees? There's been so many scams lately, as you might know from the news. Don't give people money over the internet without seeing the place or having somebody trust you the place and maybe get a set of keys. So there's big landlords and they have their own websites. Smaller landlords do tend to use Kijiji more because it's cost effective for them. But again, you're going to have to kind of go with your gut a little bit. Use the buyer beware, ask questions, get it in writing, and you're going to have to kind of make a decision on that. So one thing that we've seen recently is that tenants are getting challenged about the landlord when they're leaving an apartment. Okay, so if you're leaving an apartment, you want to terminate your lease, you need to be very clear as to what your notice periods are. If you're in a month-to-month lease, periodic lease, then you have to go with this. And there's a particular form called a Form C that's accessible at Access Nova Scotia. It's available in PDF format. I'd recommend filling that out and handing that to the landlord, keeping a copy for yourself, or sending it through email. If you don't get a proper notice, you can be on the hook for rent, even when you're not living. Particularly if you're in a fixed term lease. If you're in a fixed term lease and you want to leave early, you need to make sure you cover those bases and agree that you can exit the lease without penalty, through assigning it to somebody else or by agreement with the landlord. So those kinds of things are very important, and I don't think a lot of students and tenants generally don't realize that there are clear rules about when and how to give a landlord notice to end tenancy.
Absolutely. Thank you for that.
No problem.